Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations related to steno. Be ready for the high speed passage. Let us now examine whether a contractor engaged to execute a particular work can file a suit for accounts against the employer in regard to payment for the work done. Stop. Such a right is not created or recognized by any statute. Stop. The independent contractor is not an agent of the employer, nor is the employer in the position of a trustee with reference to the independent contractor. Stop. Can the claim be supported in equity by stating that where the relationship is such that rendition of accounts is the only relief which will enable the contractor to satisfactorily assert his legal right? Question mark. A contractor who is engaged to execute a work is expected to maintain his own accounts. Stop. At all events, there is no bar for a contractor to keep an account of the work done. Stop. Even where the contract between the employer and independent contractor may provide for payment on the basis of measurements to be recorded by the employer, nothing prevents the contract oblique contractor from measuring the work done by him and then showing for the value of the work done. Stop. The contractor may also demand joint measurements to determine the quantum of work done. Stop. If the employer for some reason does not cooperate or prevents the contractor from taking a physical measurements, the contractor can seek appropriate legal remedy which will enable him to take measurements or to secure the information from the measurement book in the custody of the employer. Stop. Therefore, either the fact that the measurement book is maintained by the employer or the fact that the contractor does not possess the exact measurements will not entitle the contractor to file a suit for rendition of accounts against the employer. Stop stanza. A careful reading of section 149 shows that it would apply only in respect of the court fee payable at the time of institution of the suit. Stop. If the court fee due on the plaintiff when instituted is not paid wholly or partly by the person instituting the suit, the court in its discretion may allow him to pay the court fee or deficit court fee within the period fixed by it. Stop. Section 149 has no application where the court fee due on the plaintiff as per the valuation of the suit is fully paid, but subsequently it is found that a larger amount is due to the plaintiff. Stop. For example, if the plaintiff values the suit at rupees 2 lakhs and the court fee payable is rupees 20,000 and the plaintiff pays a court fee of rupees 10,000 on his request, time for payment of balance of rupees 10,000 can be extended by the court at its discretion under section 149 CPC. Stop. But where the claim was rupees 2 lakhs and full court fee of rupees 2 lakhs was paid at the time of institution of the suit, the question of permitting the plaintiff to pay deficit court fee at that stage does not arise, as no court fee becomes payable at that stage. Stanza. In this case, the appellant could have either himself measured the work done by him or secured the information from the respondent's. Stop. The appellant has neither made out a right under a statute nor any fiduciary relationship nor any right in equity by establishing that as except by calling upon the defendants in the suit to render accounts, it is not possible for him to get relief. Stop. The appellant has sued for rupees 2 lakhs and paid court fee thereon. Stop. Nothing prevented him from suing for rupees 5 lakh 33,000. Stop. In para 5 of the plaint, he states that the total value of work done by him was rupees 10 lakh. Stop. He knew that he had been paid only rupees 4 lakh. Stop. He also knew that value of material supplied by the employer. Stop. In these circumstances, the prayer for rendition of accounts is not maintainable. Stop. The appellant next attempted to press into service the prayer Section 149 of CPC to contend that he ought to have been given an opportunity to pay the deficit court fee on the total amount due to work done. Stop. Section 149 provides that where the whole or any part of court fee prescribed for any document has not been paid by the court at any stage, allow the person by whom such fee is payable to pay such court fee. Stop stanza. On a careful reading of the aforesaid paragraphs of the election petition contained in Annexure 1 of the writ petition, it is clear that election petition contains an adequate statement of all material facts on which the allegations of not only illegality in counting of votes were founded but specific allegations of manipulation and fraud played by returning officer while counting of votes were levelled with material particulars. Stop. Not only this, but the petitioner had also adduced voluminous evidence to support the allegations levelled in the election petition in respect of aforesaid illegalities and manipulations in counting of votes by entering himself in witness box and by examining his counting agent. Stop. The aforesaid version of election petition was also supported by other candidates by filing their affidavits before the election tribunal, which clearly established that the petitioner had adduced sufficient evidence affording a good ground for believing that manipulation was done and fraud was played while counting of votes by returning officer. Therefore, in my opinion, the only way to decide the dispute and to do complete justice between the parties was an order for recounting of votes. Stop stanza. From perusal of impugned judgment and order passed by the election tribunal, it appears that the statement of petitioner and his agents in respect of manipulation in counting of votes has been rejected without any cogent reason. Stop. It appears that while dealing with issue, the election tribunal, under wrong notion of law, has illegally assumed that the petitioner was required to prove his allegations made in the election petition beyond reasonable doubt, whereas, in view of legal position enunciated by Honorable Apex Court and this Court from time to time, as indicated herein before, such standard of proof for inspection of ballot papers for the purpose of recounting of votes is not at all necessary. Stop. The election petitioner was required merely to adduce such evidence on the basis of which allegations could be prima facie established, affording good ground for believing that there has been mistake or illegality or manipulation in counting of votes, and further, on the basis of such evidence, court or tribunal trying the election petition could be prima facie satisfied for directing inspection of ballot papers or recounting of votes. Stop stanza. A distinction between prima facie opinion and conducted opinion was required to be kept in mind, but while rejecting the prayer for recount of votes, in my opinion, the election tribunal has proceeded completely on wrong notion of law and rejected prayer for recount of votes on the ground that the petitioner has failed to prove his case. Stop. In this connection, it is the noted that when the allegations in the petition were not vague or indefinite or frivolous, rather they were very specific in terms and supported by oral evidence adduced before the election tribunal, inasmuch as affidavits of other candidates, there was sufficient material before the election tribunal affording good ground to believe that illegality or manipulation was done in counting. Stop.